Thank you all for coming to this crucial conversation, which ought to be interesting. Two things I want to point out. One is we're happy to be at the North Carolina Association of Educators, and we love public schools, of course, too. And today's a great day to be talking about the courts and education. As you know, Judge Hopgood, if you don't know, just ruled the voucher scheme passed by the General Assembly 2013. So it's a perfect day to talk about the courts and how important they are to our lives. And we have a great speaker that Rob will be introducing in a second from Center for American Progress. But I also want to mention our courts and law reporter, Sharon McCloskey, and our education reporter, Lindsay Wagner. And if you also watch, you're not here, they're actually back to the office writing up a story about what happened today and sending that out. So thank you all for coming. Without further ado, I'll turn it over to Rob.
Thanks, Chris. Thank you all for coming today. We're really delighted to have you, and hello to our online audience as well that will be watching the recording of this program online. Today I'm really delighted to introduce to you Ian Millhiser. He is the Senior Constitutional Policy Analyst at the Center for American Progress in Washington. And I assume most of you are familiar with the Center for American Progress, but if you're not, you should be, because it is one of the most important progressive organizations in our country these days. They have a large and vibrant staff that are defending civil rights, defending civil liberties, defending really the notion that public structures and services play an important role in our society, and defending them against the assault that's been sort of constant from the right-wing groups. And they've done a wonderful job, and they continue to. We're delighted, we're lucky to have them. Ian is an attorney with an impressive legal resume, and he's someone who actually participated in defending the Affordable Care Act, the litigation to do that. Congratulations to him for that. He is a veteran of innumerable media interviews. How many did you do the day of that? Was it like 40 interviews?
I don't even want to think about it.
So you'll undoubtedly occasionally, when you're flipping through the cable channels, you will see him there. But it's interesting, as we were at dinner last night, he said to me that he really thinks of himself more as a journalist now these days, even though he is, of course, an attorney, and that Think Progress, which is the sort of front page of the Center for American Progress, much in the way sort of Policy Watch on a very micro level is the front page of the North Carolina Justice Center. He thinks of himself and his colleagues as sort of being in the Think Progress newsroom, and they really think of themselves as really the modern news media in many respects. And so I think it'll be interesting to hear his perspective on the Supreme Court of the United States, both as an attorney and as a journalist. He's actually writing a book right now. Is it finished?
Yeah, they just sent the manuscript off on Friday.
The manuscript. So this is a celebration for him. On the U.S. Supreme Court, not just recent years, but really the history of it over the last century or more. And I think from the way he's described it to me, it's an interesting perspective that many of us probably haven't thought about the court in this way. So it'll be the title, the working title, as I understand it, is Injustices, and the subtitle is still to be narrowed down. But so stay tuned for that and be on the lookout for that book when it comes out in 2015. Today, he'll share his views on several important Supreme Court issues, and although he is a modern a man of the media, he has told me he's allergic to PowerPoint, I'm happy to report. So he'll be just talking to you the old-fashioned way today. But his subject matter is a sobering one. There are some bits of good news. It's not all dark shadows, but for the most part, he will be listing some of the challenges that we as caring and thoughtful progressives have in front of us. And I guess the only other thing I would say that one of the things that gives me hope as we approach the challenges he will be describing is that we have, I can say this, young men like Ian who are incredibly smart, talented, passionate people to help lead us in this fight in the years ahead. But I think you'll come out of today's event much better informed about the Supreme Court and the challenges that lie ahead. So please join me in welcoming Ian Millhiser.
Thanks, Rob, although I will note that it is almost all dark shadows. I thank all of y'all for coming out for what I assure you will be a very depressing talk. So I guess I should open with one story about good news, which is the day that U.S. v. Windsor was decided. That was the recent decision striking down the Domestic Marriage Act. And it was a big day. You know, it was a big day for me because we don't get a court victory in a major Supreme Court case every decade, and so it's nice to experience one. Some of my colleagues were in their 20s; they'd never experienced one before, so like it was nice for them to have that experience during their professional careers. And one of my colleagues actually brought out a bottle of champagne after the decision was handed down. And we poured ourselves glasses, and since I'm the Supreme Court specialist, it came to me to do a toast. And the toast was to Tony Kennedy. You are an ass, but today, you are our ass. So, ladies and gentlemen, I'm here to talk about all the times when he has not been our ass. I'm here to talk about many of the decisions that this court, and if I get to it, some previous courts have handed down that have not been a cause for champagne. Before I do, I actually want to talk about the brain. There's been a lot of interesting research done on how people who have strong partisan views process information. One of the seminal studies that was done during the 2004 elections, they hooked solid Republicans, hardcore Republicans, and solid Democrats. So this isn't a partisan thing. It happens to all strong partisans up to a machine that scanned their brain and saw which parts of the brain was firing at different times. And then they exposed them to information that was unflattering to their party's candidate. So the Bush supporters got unflattering news about George W. Bush. The Kerry supporters got unflattering news about John Kerry. And what they found was that when this happens, when a partisan is exposed to unflattering news that challenges their political beliefs, the parts of their brain that are associated with calm, rational thinking do not fire. What actually happens is that the brain has a reward and punishment system where immediately the parts of the brain associated with emotional distress start to fire. And they keep on firing until the brain finds a way to rationalize that information away. And when that happens, the parts of our brain that are associated with pleasure fire. In fact, one of the researchers associated with this, who performed the study later said that the sections of the brain that fire at that moment where the information is rationalized away are the same sections that fire when a drug user gets their fix. Strong partisans are literally addicted to their views. And so I want you to think about that study as I talk about an institution that is made up of 9 people, most to all of whom have very strong partisan views, that are appointed through a process that rewards the presidents who picks the most committed partisans. Because if you pick someone who wavers, then your legacy suffers for the next 20 or 30 years. And they are unaccountable. The scary thing about what, the psychological term for what this study was describing as motivated reasoning. And there's been a lot of studies looking at this. There's one recently dealing with vaccine deniers, people who claim that vaccines are no good for you. And it found that if you give a vaccine denier information showing why, no, actually vaccines are good and your kids should get them, they will emerge from the experience as an even more hardcore vaccine denier. Like that, this is how our brains work when our strongly held views are challenged. And that is how Justice Scalia's brain works. And I shouldn't pick on him. I mean, that is also how Justice Ginsburg's how her brain works when she is presented with information that challenges her most strongly held beliefs. And yet we give 5 people, because it only takes 5 of them, whose brains operate just like the rest of ours, the ability to make these sweeping decisions, and we give it to them without any way to check them. And I think that provides some explanation for how some of these cases have come down the way that they did. When Rob asked me to speak, he told me he wanted to spend some time talking about the Hobby Lobby decision. But I actually don't want to start with the Hobby Lobby case. I want to start with a less well-known case called Fremont Christian. It's a case from the 1980s. It's a case that didn't reach the Supreme Court because at that point the law was very clear that you couldn't use a so-called religious liberty claim in the way that this school, Fremont Christian, wanted to use it. Fremont Christian was a school, and they had a very unusual employee benefits program. If you were a man, you got health insurance. And if you were an unmarried woman, you also got health insurance. But if you were a married woman, their religious belief was that the husband should be the provider for the family, and therefore the woman shouldn't get health insurance because she should get it through her husband. That was what they believed God wanted. And so they sued, challenging Title VII, which is the law that forbids various forms of employment discrimination, claiming that they should be exempt from it because their religion commanded them not to provide health insurance to married women. And the Court of Appeals, the Ninth Circuit, looked and said, "Are you kidding me? You know, of course you don't get to use a religious liberty claim in that way." The rule that prevailed for a very long time, up until about 2 months ago, was essentially that my religious liberty stops at your body. You know, we have sweeping religious liberties in this country, and we should have them. But what we cannot use them for, we can use them to protect our own ability to carry out our faith, to protect our own conscience, but we cannot use them to diminish the legal rights of others. And that's why this school, Fremont Christian, wasn't able to win its case, because it was trying to use religion to take rights away from many of its employees. And that's what Hobby Lobby tried to do. That's what Hobby Lobby succeeded in doing. You know, under the Affordable Care Act and the regulations that have been promulgated under them, if you have an employer-provided health plan, there is a minimum level of benefits that that plan is required to cover. Part of that minimum level of benefits is that it has to provide coverage for contraceptive care. That is the law. That is your right as an employee at an organization that provides you with employer-provided benefits. And the Supreme Court said for the first time in American history that that the right of the employer in this case trumps the right of the employee. And I just want to be clear that, like, I'm not making this up when I say that that was the rule. I'm going to read you from a case. This is a case called United States v. Lee. It's a 1982 case where there were a group of Amish employers, and for religious reasons, they didn't want to pay Social Security taxes. They claimed that they should be exempt from paying Social Security taxes. And the Supreme Court, it really was a unanimous decision. Justice Stevens wrote a separate concurrence, but in his separate concurrence, he said the court should have gone even further. So it was a unanimous decision, and this is what the court said. They said that when followers of a particular sect enter into a commercial activity as a matter of choice, the limits they accept on their own conduct as a matter of conscience and faith are not to be superimposed on the statutory schemes which are binding on others in that activity. That was a unanimous Supreme Court decision. Chief Justice Burger, who many of you probably know was no liberal, wrote those words. And then Chief Justice Burger went on to explain that the reason for this rule is because when employers are allowed to use their religious faith to diminish the rights of others, they act to impose their religious beliefs on someone else, and that is not allowed. That is, among other things, an infringement on that other person's religious liberty. And that was the law up until Hobby Lobby. I could go into some of the details about legally what Hobby Lobby was wrong. The history here is a little complicated. There was a decision in 1990 that sort of blew up our religious liberty law and made it narrow in a way that no one liked. Congress passed a law in 1993 whose purpose was to restore the law exactly as it existed the day before that 1990 decision. And when I say the day before, that includes U.S. v. Lee. That includes that language that I just read. And Alito, I mean, it's somewhat of a baffling opinion that he wrote in Hobby Lobby. said that an irrelevant 1997 amendment that changed an irrelevant definition section of the law somehow trumps that history. And all of a sudden we're not hitting the reset button and we're not restoring the law as it existed before 1990. We're actually creating a whole new regime where the employer's right can trump the employees. And I think, that's not just legally wrong, it's very frightening. And it also brings me back to this Fremont Christian case. The most ominous part of Alito's opinion, and it was a rather ominous opinion, is at the end of the opinion, he says, Justice Ginsburg's dissent and some other folks have argued that if this rule is breached, if we allow the employer's right to trump the employee, then that's going to lead to race discrimination. And he does explicitly say, and good for him that in 2014 he says this. He does say that race discrimination is not allowed. So good for Sam Alito on that note. But he does not say that a religious liberty claim can't be used to allow gender discrimination. And he does not say, perhaps most ominously at all, if you're aware of what's going on in the courts and where the Supreme Court tends to disagree, he does not say that a religious liberty claim cannot be used to permit discrimination against gay people. Typically when you're looking at a legal document and the court itemizes one thing that they say is not allowed, and they are silent on other things, lawyers assume and judges assume that silence was done with a purpose. We assume that the reason they called out one thing, they didn't call out other things, is because they didn't want those other things to be protected. And so the implication, at least of what Alito wrote, is that if you want to discriminate against women, if you want to discriminate against gay people, potentially if you want to discriminate for any reason other than race, and you believe God agrees with you, you think you have God on your side, go for it. That's the implication of Alito's opinion. There was some language, Justice Kennedy wrote a concurrence, and so I should be fair and point out that it is possible that Justice Kennedy won't go that far. But I don't think there's really any doubt in my mind, and Alito's come very close to saying as much in past opinions, that Alito would go that far, and that he'd bring at least 3 other justices along with him. So that's the Hobby Lobby case. I think Hobby Lobby dovetails to 2 other issues that are of particular concern with the Supreme Court. It was a case about religion, but it was also a case about health. It was a case about employees who wanted access to a very common health treatment. One that in some cases is essential to preserve a woman's life, and in virtually every case is essential to women's equality. And yet the Supreme Court said that this very common method of obtaining health care was not protected. So I want to talk a bit about health care, and it's also a case about workers. It's a case about the rights of workers vis-a-vis their employer. So I'm going to talk a little bit about how the Supreme Court has treated workers as well. And I think I want to start with the piece about workers, because there was another case which also has implications for health care that the Supreme Court handed down the same day as Hobby Lobby. It was also written by Justice Alito. It was a case called Harris. Harris, and this is something that really wasn't on anyone's radar at all before Alito joined the court, is part of what looks like it's going to be a 3-step process towards turning every state into a right-to-work state, at least with respect to public sector unions. So it's kind of appropriate that I'm giving this in a building owned by a teachers union, because the goal of lawsuits like Harris is to defund this teachers union. And in this case, it potentially succeeded in defunding a union that represents Medicaid home health workers. So before I go into the details of the case, I just want to point out what these workers were doing that benefit from this union. These were workers paid through the state Medicaid program that provide often 24-hour care to people who are no longer able to take care of themselves. I mean, it is the sort of services they provide. It's not even medical care. It's often just like allowing people to have basic dignity. It's allowing them to eat. It's sometimes helping them go to the bathroom. I mean, these are the most vulnerable people who are served by these workers. And before the union came along, these workers were paid $7.50 an hour. Now, I hope that I'm never in the position that I need that kind of care, but if I ever do, I hope the person who provides it to me is paid more than $7.50 an hour. I don't want my ability to get through a day and to perform the most basic test, the most basic task, to rest in the hands of someone who barely makes the minimum wage. And when the union came along, the union successfully negotiated them a wage increase up to $12 an hour. So this is a successful union. What this case was about is it's about something called agency fees. And what agency fees are is that in many states, you have a choice. In every state, you have a choice whether or not you want to join a union if you're in a unionized workplace. If you don't join the union still has to bargain on your behalf. So if you don't join, you still get the higher wages, you still get the increased benefits, and this creates what's called a free rider problem. The problem with this regime is that if I can get all the benefits of being in the union and not join the union, I have no incentive to join the union. So agency fees are what prevents that free rider problem. Agency fees are if I do not join the union, but the union bargains on my behalf, I have to reimburse the union my share of those bargaining costs. And the bargaining costs can be significant when you look at them in the aggregate because they frequently require you to hire lawyers, sometimes requires you to hire economists, and it's a pretty involved process. If unions can't collect these agency fees, then it's a fairly effective method of defunding the union, because it takes away the incentive of the people in the bargaining unit to provide any money to the union at all. They'll still get everything. And so the risk is that the union withers on the vine, and then all these people who are now making $12 an hour will go back to making $7.50 an hour. Justice Alito, in his 5-4 opinion in Harris, said that, at least in the context of this public sector union, and he suggested that potentially in the context of all public sector unions, these agency fees are unconstitutional. He had a rather twisted First Amendment reasoning, which I try very hard to get my head around, and I can explain it to you, but I promise it makes no sense. But the punchline of this, you're setting aside the fact that First Amendment's free speech has nothing to do with bargaining. When I got my job, we had a conversation. My mama, Cap said, "Hey, we want to pay you this much," and I said, "No, I'd like you to pay me this much." And those were words we were using. That was speech. If free speech prevents those sorts of negotiations from being regulated, we can't have minimum wage laws. You can't have laws protecting employer benefits. You can't really have much regulation of the workplace at all if bargaining is something that's covered by the First Amendment, because bargaining is the nature of any negotiation with your boss over what you're going to be paid, what your work hours are going to be, what your benefits are going to be. It's all a conversation. So it's a very bizarre decision that Alito handed down. And it's one that I think reflects a certain disconnect, in that if you read the decision, the sense that pervades it is that the union is this sort of venial organization that's trying to suckle money off of a teat that does not belong to it. And I go back to how I started talking about this, because that's not what the union is doing here. This union is providing an adequate wage, or not really a great wage, but a much better wage, to people who provide the most intimate care to the most vulnerable people in the state of Illinois. That's what this union does. it doesn't just ensure that those workers can have a share of dignity, but it ensures that the people that they care for, that when they don't have to worry that their worker has other concerns on their mind, and it ensures that they are cared for by a higher quality of individual, because you hire better people when you pay them more. So there's this disconnect in the Supreme Court where they have lost the sense that, when you pay people a way that treats them with dignity, America as a whole benefits. When you give workers the opportunity to have adequate bargaining power, that isn't just something that benefits this, organization that they pay dues to. It's something that benefits them, and by extension, reaches out to benefit the people that they serve. And it benefits the local businesses, because when they're paid more, then they'll have more money to spend in the local businesses. That sense is lost in the Supreme Court. And instead, it's been replaced by a very creative sense of how the court can look at laws and use them to diminish the rights of workers. There was a case 2 years ago called Vance. 2 years ago, about a year ago, called Vance. Vance dealt with sexual and racial harassment. And the rule in harassment cases is that if your boss harasses you, the legal term is your supervisor. If your supervisor harasses you, then the employer is automatically liable for it. So it's much easier to win a harassment case, whether sexual or racial, if it's your boss doing it. If it's just a coworker, those cases are very hard to win. And the court basically eliminated, it should be obvious why we have special protections for people who are harassed by their boss, because their boss exercises a degree of control and power, the power dynamic's different there. But the Supreme Court virtually eliminated that protection in many workplaces, and they did it in a very odd way. They changed the definition of what a supervisor is, so that now you're only a supervisor if you have the power to hire, fire, promote, or similarly change the working conditions that someone has. And I don't know about y'all's offices, but the way that my office operates, the way that many offices, and I think virtually all larger offices operate, is that the power to hire, fire, promote, demote people, the ultimate power to do that generally doesn't rest with people's bosses. It rests with the HR department. My boss's job title is Senior Vice President. He is not a supervisor, according to the Supreme Court of the United States. And the reason why is because if he wants to fire me, he can't just say, Ian, you're fired, hit the bricks. If he wants to fire me, he emails HR and says, hey, we need to fire Ian, and then I get called into a meeting with the HR manager and I get fired. According to the Supreme Court, my supervisor is not the guy who directs my work every day, not the guy who does my evaluation every year, not the guy who, in our org chart says I answer to. It's the HR manager that I see maybe 3 times a year. And what that means is that protection that people have historically had against being racially or sexually harassed by their bosses in many offices ceases to exist. And there are many cases like this where the court has, in very creative ways, diminished the rights of workers in the workplace. There was a case called Gross a few years ago that made it very hard to sue for age discrimination. It made it very hard because it made it so that you essentially had to prove the state of mind of your boss, and that they were actually thinking, yes, I am firing this person because I do not like the fact that they are too old, and that they didn't have some other motive at the time that they did it. There was another case that was handed down the same day as this sexual harassment case I talked about, Vance, which said the same thing about people who are victims of illegal retaliation, that you essentially have to be a mind reader now to prove those cases. And then there's the most famous case where the Supreme Court engaged in a little creativity to diminish the rights of workers, and that's the Ledbetter decision. A lot of you have probably heard of Lilly Ledbetter. And the reason you've probably heard of Lilly Ledbetter is because Lilly Ledbetter was at the eye of what I would describe as the perfect political storm. that led to Ledbetter being one of the few Supreme Court cases that was overturned by Congress. There's a very effective lobbying team behind overruling Ledbetter. I know many of them. There was President Obama figured out very quickly that this very telegenic plaintiff that a lot of people thought had been treated very badly would be a good person for him to rally around in his presidential campaign. So she was featured in an ad. She got to speak at the DNC. And then President Obama won a wave election where Democrats had nearly unprecedented majorities in both houses of Congress. And even under those circumstances, the Lilly Ledbetter Fair Pay Act only passed the Senate by 2 votes. So it took a perfect storm to fix what the Supreme Court had done. It took one of the nation's great political parties really rallying behind this woman immediately before they won a wave election to fix that problem. Jack Gross, the plaintiff in that age discrimination case I mentioned, he didn't get to speak at the DNC. Amelia Vance, the woman in the harassment case, she's not going to be speaking at the DNC in 2016. I doubt very much you're going to see a worker from Hobby Lobby speak at the DNC anytime soon. And what the data shows is it shows that Congress has been increased. It is now far less effective in checking the court than it used to be. Between 1975 and 1990, the Supreme Court was overruled by Congress about 12 times every 2 years, so 12 times in between elections. And some of those were minor tweaks, some of those were rather significant, but about 12 times between elections, Congress would go in and say, yeah, there's the Supreme Court thing that the Supreme Court did, we want to make that different. Now that happens about 2.7 times between elections. So Congress is less than a quarter as good of a check on the Supreme Court as it was about 30 years ago. And that has tremendous implications. That means that these unelected officials in Washington, the one branch of government that's not elected, has sweeping power, often driven by this motivated reasoning that I talked about at the beginning of my speech. And one of the traditional means of checking their power, they've always had the power to hand down constitutional decisions that were almost uncheckable. But generally when they mangled a statute, Congress could say, no, that was wrong, we're going to fix it. That's not happening anymore. And so the least democratic part of our government is becoming more and more powerful every day, largely due to congressional dysfunction. Because the Supreme Court's capable of acting and Congress ain't. I want to talk about one more issue and then I'll stop talking. And that is like I said, as I said, healthcare. And there's 2 issues coming up there that I think are very troubling. One is these things called trap laws that a lot of y'all have probably heard of. And before I get into trap laws, I just want to point out where we stand with abortion generally. Because there's a perception out there that there've been restrictions on the right to choose, but Roe is still good law. The greatest trick the Supreme Court ever pulled was convincing the world that Roe v. Wade still exists. Justice Kennedy is ostensibly the swing vote on abortion. He became a justice in 1987. He has considered 21 abortion restrictions in his time as a justice. You know how many of them he upheld? 20. He has not cast a pro-choice vote since 1992. So here comes these trap laws. Trap laws, like we've got one in North Carolina. There's a big case dealing with one that was just decided down in Texas. Trap laws are essentially sham health laws. They're laws that on their face look like they are passed to protect women's health, but they're really just enacted to create burdens on the right to choose. So some of them will create architectural requirements. They'll say that if you want to run an abortion clinic, the halls have to be this wide, and the building has to be built in this and such way. And what that means is that if you're a Planned Parenthood clinic and your halls aren't that wide, You have to do an expensive renovation if you want to keep operating, even though there's no real reason for the halls to be that wide. The stated reason, hospitals have regulations saying the halls have to be a certain width, and the reason why is because if 2 beds are going down the hall, they have to both fit. But in abortion clinics, you rarely have 1 bed going down the hall, much less 2. So it's a sham. A form of trap law that's particularly in vogue right now is creating unnecessary credentialing processes for doctors who perform abortions. So in Texas, the law is that the doctor has to have admitting privileges at a nearby hospital. And again, the stated justification for it is that, well, if the doctor has admitting privileges and there's a complication, then the doctor will be able to get the woman into the hospital faster. Now, first of all, that's not how being admitted into hospitals works. I was sick a month ago and I went to the hospital and the doctor said, oh, one of your blood tests looks a little weird, you need to go to the emergency room. And so my doctor called the emergency room and said, hey, I'm sending this guy over and I'm gonna email you his test results and here's what I want you to do. And it's not like I got there and then they said, wait a second, that guy didn't have admitting privileges. You've got to go in the special waiting room. No, they treated me, and they treated me quickly, or as quick as anyone else who goes to the emergency room. So it is an irrelevant credential. Plus, complications from abortions are exceedingly rare. You're 3 times more likely to die from a colonoscopy than you are to die from an abortion. But setting that aside. The purpose of these laws is to regulate abortion out of existence, or at least nearly out of existence, by creating burdens on the people trying to provide the service, so that it is too expensive to do it, or so that the universe of doctors who are legally allowed to perform the service is as close to 0 as possible. And if the Supreme Court upholds these things, depending on what they say, that could really be the end of Roe altogether in any meaningful sense. A woman will theoretically have the right to an abortion, but if North Carolina can say, well, you can't have an abortion unless the doctor, is capable of standing on their head for 6 hours because we don't want our doctors to pass out. Or if Texas could say, okay, yeah, we'll let you perform an abortion, but first you have to take a $100,000 certification class, and it has to be taught by the Pope. I told that joke, by the way, at my last meeting, and the guy said, "Art Pope?" So either one. You can imagine, all kinds of ridiculous restrictions that can be placed. And if the Supreme Court doesn't draw a line and say, no, this is an actual health regulation. And, I don't want to imply that we don't want legitimate health regulation of abortion clinics. You should have to have an MD or the equivalent if you perform an abortion. You should have to use sterile equipment. If you commit malpractice, then your patient should be able to sue you. We should have sensible regulation of all doctors. But once you cross the line from actually protecting women's health into just trying to take away the right to choose, there has to be a line there. And if there's not, then I don't know what more exists of Roe. I'll talk about one other case that's coming up, and then I promise you I'll shut up. And that's this How Big case. How Big is a case that was just decided by a divided panel, 2 Republican judges on the United States Court of Appeals for the DC Circuit, tried to defund a whole bunch of Obamacare. And I don't know if there's a lot of Seinfeld fans in here. There's a funny old Seinfeld scene where George Costanza's playing Trivial Pursuit. And there's a question, it's who invaded Spain? The correct answer is the Moors. But there's a misprint on the card, and it says the Moops. And he gets very angry because the other guy said, no, it's the Moors, and they have a big fight because the card says Moops, so that must be the correct answer. That is the legal theory behind the How Big case. This is a lawsuit claiming that the moops invaded Spain. And here's how it works. There is a line in the Affordable Care Act which, taken out of context, does suggest that in many states, in states where the federal government runs the exchange and not the state government, those exchanges aren't eligible for federal, the people who shop in them aren't eligible for federal subsidies. The line refers to an exchange established by the state. And so if you read that line alone, it suggests, it takes you to a pretty dark place. It suggests that all these people in mostly red states, including, I believe, North Carolina, where the federal government runs the exchange, if you have an Affordable Care Act plan, you're not entitled to subsidies. Which is not how anyone thought the law was supposed to be read at the time it was passed. And several reporters who covered it have come out and said, wait a second, that's not what I remember. And sure enough, if you read the statute as a whole, it soon becomes very, very clear that that's not what Congress was trying to do. There is another provision of the law, I've got a long list of these, I won't bore you with all of them, but there's another provision of the law that says that any exchange shall be an entity operated by the state. That's a definitional phrase. It suggests that, like, if you're an exchange, you are defined to be one that is operated by the state regardless of whether you are. There's a provision saying that the Secretary of Health and Human Services shall establish an exchange if the state doesn't do it, and that she shall take such actions are necessary to implement such other requirements as are mandated elsewhere in the law, which suggests, again, that the federal government has the power to implement all of the requirements to get an exchange operating, including the subsidies. The subtitle of the provision that is at issue here is affordable coverage choices for all Americans. It's not affordable coverage choices for all Americans unless you're in a red state. So, so the idea behind this lawsuit requires you to read one line and just one line and ignore the rest of the law. And that's not how laws are typically read. I mean, the Supreme Court has been very, very clear that laws should be read holistically. When there's a particular provision, you read it in the context of the whole to figure out what Congress was trying to do. So this is a very silly lawsuit. And yet, maybe because of motivated reasoning, maybe because they didn't read all the same Supreme Court cases that I did, but for whatever reason, 2 Republican judges fought this lawsuit. And if the Supreme Court takes this case, we're trying to get the full DC Circuit to overrule it. But if the Supreme Court takes this case, and if they buy this theory, that would mean that millions of people will lose their health care overnight. That would mean, I want to be clear about what that would mean. There are people right now whose life literally depends on the fact that they have a plan through the Affordable Care Act. In some cases, their life depends on it because they relied on the fact that they have that plan. If you receive an organ transplant, there are certain transplants that you cannot receive unless you can prove that you will be insured for the rest of your life. And the reason for that is because there's a constant danger that your body will reject the organ. And so you have to take drugs your entire life to ward off that rejection. And if the doctors are unsure that you will be able to stay on those drugs your entire life, they have to give the organ to someone else. And so there are people right now who are walking around with organs that are sustained by drugs they can only afford if the Obamacare subsidies exist. These people will die, and we can point to them and identify who they are if the Supreme Court decides how big the wrong way. And then there are all the people we can't identify who will also die. There was a study that was done by, I think, 3 Harvard physicians before the Affordable Care Act became law, found that in a year, about 45,000 people die every year because they don't have health insurance. Some of them were people with pre-existing conditions who couldn't get them. Some of them were people who just didn't get health insurance for whatever reason, and then they were hit by a bus. We don't know in advance who these folks are. But it's 45,000 fathers who will never kiss their daughters again. 45,000 wives will never hold their husbands again if this law doesn't exist. And I thought we already won this case. I'm not convinced that if Chief Justice Roberts was unwilling to kill the Affordable Care Act before most of it went into effect, I don't think he's going to be willing to kill it this time around when he's actually going to be personally responsible for ripping health care away from millions of people. But it's a frightening case. And it's one that, while I think we're going to win it if it goes up to the Supreme Court, we can't be certain about. So I promised you this would be depressing. And I guess I'll leave you on that note and take your questions. Kennedy is very conservative. I've told you his record on abortion. He voted not just to strike down one part of the Affordable Care Act, he voted to repeal the entire law. Think about that. As we were reminded over and over and over again during the big debate over this law, this is a 2,000-page bill. There was one line that Justice Kennedy found effective, and based on that, he said, we're going to throw the whole thing in the trash. It's a pretty conservative guy, but for whatever reason, he thinks gays are fabulous. So, good for him on that front. Literally every single one of the Supreme Court's major gay rights opinions have been written by Justice Kennedy. It's a case called Romer in '96. There was Lawrence v. Texas in 2003, and then recently Windsor. In a case called Christian Legal Society, which was a bit unusual because it was framed as a free speech case and not as a religion case, but that really presented this issue of whether a religious conservative group could discriminate against gay people. Kennedy broke with the other conservatives, and Alito was forced to write a dissent. So Kennedy has been good on gay rights. He's been slow. Romer was in 1996, and the 14th Amendment was ratified in 1867. So I'm not quite sure what's taken so long. But he's been good, and I think it is more likely than not. I'll say strongly that I think it is quite likely that the Supreme Court's going to wind up taking one of the marriage equality cases that are making its way up, probably the Utah case, and they will say in a 5-4 decision, probably written by Anthony Kennedy, that marriage equality is the law of the land. So that's the one thing that we've got to look forward to in a term where they could also got Roe v. Wade, and there's also this Helbig case coming.
Okay, now we've got some questions. Let's over here first and then here.
Thank you very much.
And remember, we're recording this, so try to speak up as loudly as possible.
Well, I'm glad that Medicare covered my colonoscopies. Under the Mental Health Parity Act, if a church believes that mental illnesses is caused by demons, would it have any obligation for treatment or for medication? Would it affect the formulary? And how about the smoking issue? Coverage and medication for employees who don't believe in that are prohibited.
So the smoking issue question is a little easier because the Affordable Care Act itself does allow some discrimination against smokers, like they can be charged higher premiums. So there are, you can't, an insurance company can't refuse to provide coverage to someone who smokes altogether, and I don't believe under ERISA is the law that, ERISA as amended by HIPAA and all these other lovely word or letter salads that we have to learn when we are lawyers is the law that governs employer benefit. I don't think that they allow outright exclusion of smokers, but at least under the Affordable Care Act plans governed by the ACA, there is some discrimination allowed in terms of premiums. The question about mental health is harder So Alito, in his Hobby Lobby case, did have a line where he just said, like, he didn't bring up mental health, but he brought up blood transfusions and a few other issues where there are sects that object to these treatments. And he basically just said, well, that would be a different case. And that's all he really said. Like, well, that's a different issue. And he implied that because it's different, he'd reach a different answer, but he didn't go that far. Kennedy, in his concurring opinion, did say that in a case where, like, there was the burden towards the employee was greater, or where, like, it was particularly more difficult to avoid, that he might flip and vote the other way. So I think there's a decent chance that, if the objection was to mental health care and not to birth control, that the court might go the other way. I can't think of a good reason to make that distinction. I mean, I think that contraceptive care is as important to people's health as anything else. But the Supreme Court, Alito's opinion, and to some extent Kennedy's opinion, at least suggested that, like, they may view birth control as off as this special class that will be treated inferiorly to other forms of health care.
Gentleman right here.
Would you explain the court's reasoning on how corporations are like people?
Sure. I mean, I think that this is a less important issue than some folks make it out to be. It's something that became a big deal after the Citizens United case. The theory, and I mean, the word person in the law doesn't mean what you and I normally think it means. Like, normally when lawyers use the word person, they're referring to a concept called legal person, and that is like any entity that has legal rights. And so, like, and I don't necessarily think it's ridiculous to say that a corporation can have constitutional rights. If the police decide to break into someone's corporate headquarters without a warrant, I think the corporation should be able to sue the police. I don't know that corporate personhood is necessarily the enemy. The enemy in cases like Citizens United is that, for at least going back to the 1970s, the Supreme Court has said that the government has a compelling interest in preventing corruption. And that's why we can have campaign finance laws, because campaign finance laws prevent the corrupting process whereby people use money in order to get favors or in order to put in lawmakers that we can't trust because we don't know whether they're acting on our behalf or whether they're acting on their donors' behalf. That's why the court, has said that we can have campaign finance laws. And what happened in Citizens United, and then they sort of doubled down on this in a more recent case called McCutcheon, is they defined the concept of corruption so narrowly that it hardly exists. They said that the only thing that counts as corruption is quid pro quo corruption, where a person comes to the lawmaker with a bag of money and says, here is the favor I want from you. I want you to vote for this bill, or like, if I can give actual examples from the Nixon administration. I want you to appoint me ambassador, or hi, we are the dairy industry, and here is $2 million, and we want you to put the following price controls in place. This is actual things that happened in the Nixon administration.
It actually happened in the North Carolina General Assembly.
Well, yeah, that too. And so that is still considered corruption. If you actually go to a lawmaker and say, here's my bribe, and here's what you need to do in order to get this bribe, that's still something that the Supreme Court says is corruption. But if a lawmaker, and I swear I'm not making this up, they have said that dollars for access is not corruption. So if I'm a congressman, and I put up a menu in front of my office, and I say, if you want 15 minutes of my time, that'll cost you $10,000. I'm not going to promise you anything. I might tell you, I might tell you to blow off. But if you get 15 minutes of my time for $10,000, 30 minutes, that's going to cost you $20,000. By the full hour, I'll give you a discount, $35,000 for an hour, and I just put up a menu outside, and any lobbyist can come along and buy my time and tell me whatever I want. According to the Supreme Court of the United States, that is not corruption. That's what Citizens United held. That's what this McCutcheon case held. And that's the problem. You know, when you look at who is funding all of these ads, some of it's coming from corporations, but most of it's coming from wealthy individuals. You know, Sheldon Adelson is this guy who is worth more, and I'm not making this up. If you add up the gross national product of the poorest 25 countries in the world, that is less money than Sheldon Adelson's assets. That's how rich this guy is. Sheldon Adelson spent, Sheldon Adelson, I actually have to do the calculation in my head now how many figures this is. He spent 9 figures. You know, that's the hundreds of millions in the 2012 cycle. You know, we all know about our Koch. We all know about the Koch brothers. You know, and on the left we have a few of those folks too. We don't have as many of them. They aren't as generous, but they exist. And that's the biggest problem. You know. I mean, after Citizens United, we thought the problem was going to be Exxon. And you know, Exxon, you know, they may, we actually don't know because we don't know who's been laundering money through the chamber, but you know, they may have been laundering some money through the Chamber of Commerce. But the big problem is individuals. And it's, you know, that doesn't have much to do with corporate personhood. It has to do with the fact that the Supreme Court has utterly mangled the concept of what constitutes corruption in a way that no normal person would understand that word to mean.
Dave, can you talk a little more about sort of the broader reasoning or lack thereof at work in the court? It strikes me that 2 things are going on. One is pure ends-based reasoning. Just, we want to get to this end, and we'll get there come hook or crook. And it also seems to me to be leading to a revival of a kind of weird 21st century legal formalism that just, well, the law really says this, and yes, you've told me it's going to hurt 8 million people, but gee, I'm sorry, but the law dictates that it must be what it must be because the law is in this sort of pure formalistic realm, and we can't really consider social economic impacts the way they might have done in Brown v. Board.
So I think I'm very cautious about speaking in terms of the Supreme Court as if it were a single hive mind that is like, has a single theory of how the law should operate, because, you know, there are 9 justices and 5 of them actually have real power, and like, those 5, you know, they are different people. The most consistent justice, you know, the one who most reliably you can predict based on what he said in the past, what he's going to do in the next case, is Clarence Thomas. You know, I will give him that. Like, you know, Clarence Thomas has said that he wants to roll federal power back to the 1920s, and he means it. He has said that the legal theory that drove a case from 1918 that said that federal child labor laws are unconstitutional, he says, yeah, that was right. We shouldn't have those federal child labor laws. And he is consistent. I mean, I will give him that. He has a coherent theory. He thinks that the Constitution should be read as it was originally understood in 1917. That was a joke, by the way. And he's very consistent with that. Justice Alito, I think, is the most partisan member of the court. You know, I did a piece recently where I went through each of the justices, and with every single justice except for Alito, I was able to identify cases where there was like all 5 of the conservatives voted one way plus 1 liberal, or all 4 of the liberals voted one way plus 1 conservative. So like where one of them had flipped over and when the rest of their, you know, people who they tend to join did not flip. The only exception is Alito. Alito has never done that before. You know, when you watch Alito in oral arguments, and Alito is scary smart. I mean, you really should fear Sam Alito. You know, Alito, asks penetrating questions that are only directed towards one side. I mean, like, he comes in there and he asks questions that are designed to destroy whoever's on the liberal side of that case. And often he does it quite effectively. So, like, you have Thomas, who has this very coherent philosophy of law that just happens to lead us to a terrible place. And you have Alito, who I really do think, like, you know, again, I don't know if it's conscious or if it's motivated reasoning, but is basically there to do what the Republican Party wants done that day. And then, you know, you have a spectrum in between. You know, Scalia's handed down some really great criminal justice decisions because he, like, happened to feel that, like, his theory of the Constitution led to that requirement. Scalia was the key fifth vote to say that banning flag burning is unconstitutional. So, like, there's a continuum there. And, you know, I think that there are some of them who are formalists and will reach formalistic decisions because that's how they are. And there's some of them who are partisans and they want to reach the decision they want to reach, and formalism sometimes provides them a reason to do so, so they speak in terms of formalism. But I don't know if there's necessarily, like, that much coherence there. I'll make one other, you know, vaguely related point, which is, you know, I don't know if any of y'all are lawyers, but, like, if you were ever looking to sue the federal government because you think that, like, there needs to be, you know, there are legitimate reasons why at times we want to check the federal government, now's the time to do it. Because there are some, and I'm serious about this, like, you know, we've just had a unanimous decision handed down, even Alito joined this one, although we wrote a separate concurrence, dealing with whether police can search your cell phones. They said no, all of them. So, like, you know, there is a block of justices who are civil libertarians and who, you know, are uncomfortable with the government behaving in certain ways and will consistently vote that way. And there's a block of justices who hate Barack Obama. And if the Obama administration is making this incursion on civil liberties, like, they're inclined to vote against it. Now is the time to bring those cases. Because you know, when you put those two blocks together, it's a majority. But yeah, I mean, you know, my overarching point is, like, you know, they are different people, and, like, while, like, certain blocks of them tend to vote together, it doesn't necessarily mean that they think the same way.
I know time is short. Maybe right here, right in front. We've got probably time for one or two more questions.
I wanted to go back to the concept of corporations as persons. It seemed to me, and I would like your comment on this, that the court started to go off on this issue over 30 years ago when they effectively dropped the distinction between political speech and commercial speech. I mean, lawyers couldn't advertise.
Right.
Pharmaceutical companies couldn't fill the airways with their ads for prescription drugs.
Yeah.
It seems to be awful as public policy and would have been unconstitutional a little over 30 years ago.
Yeah, I mean, so
It wouldn't have been protected.
Right. Yeah. So what the Supreme Court has said, and with, you know, it's a good point about commercial speech. They've said that commercial speech gets slightly less protection than political speech, but only slightly. So, like, the legal terms here is political speech. If the government wants to regulate your political speech, it's subject to what's called strict scrutiny, which is the highest level of scrutiny under the Constitution. If the government wants to regulate commercial speech, that's regulated what's called intermediate scrutiny, which is ostensibly a lower level of, you know, like, more regulations allowed under intermediate scrutiny than under strict scrutiny, but they're very malleable standards. So, like, intermediate scrutiny, it's like there has to be an important government interest and there has to be a reasonable relation, I think it's reasonable relation is the language the court has used, between the ends that the government's trying to achieve and the means that they're using. And that's a really vague standard. And so the problem when you have vague standards is that it allows the justices to manipulate them. There was a case recently called Sorrell. And Sorrell dealt with, I believe it was a Vermont law that was intended to protect patient privacy. It's a very common practice for doctors to sell aggregated information. They don't have your name on it, so it doesn't say like, Bob uses this drug and Fred uses this drug and Cindy, but like, doctors will sell aggregated data about what they're prescribing to drug companies, and then drug companies will compile that information and use it to help their sales strategy and their marketing strategy. And Vermont banned that practice. They thought it was a patient protection practice that like your drug information is private, and even if it's anonymized, your doctor shouldn't be selling to the drug companies this information about what drugs they're prescribing to you. And the Supreme Court said that violated the First Amendment. They said that even though it's commercial speech, they said that when your doctor tells a drug company what drugs they're prescribing, that's a form of speech, and they felt that the justification wasn't good enough here under this intermediate scrutiny test. I mean, honestly, like if that had been a law school hypothetical, like if I was still a law student and I was given the facts, the professor could have asked me, write an opinion upholding this law. Now write an opinion striking down this law. And I could have written both of them because intermediate scrutiny is such a malleable test. And that's a problem that I think we have throughout the court's jurisprudence, even before the court started interpreting the Constitution. Read the 14th Amendment. Now tell me what the privileges or immunities of citizenship are. What are the liberties that we cannot be denied without due process? And oh, by the way, how much process is due? And what process, by the way? What kind of search or seizure is unreasonable? Which punishments are cruel? Which ones are unusual? And when I say unusual, do I mean unusual now or unusual 200 years ago? The Constitution is absolutely riddled with ambiguities. And a lot of the problems we've had with our Supreme Court doing crazy stuff is that the Constitution, frankly, wasn't drafted very well. It wasn't drafted with precision. And when you write something into law that's very ambiguous, what you are doing is you are delegating discretion to the Supreme Court of the United States to decide what that provision will mean. And at times they've said it means crazy things. At times they've said that one of the liberties that you cannot be denied without due process, whatever that means, is that there are very strict limits on the government's ability to regulate the workplace. There's nothing in the Constitution that says that that's what liberty means. There's also nothing in the Constitution, I guess, that says that it doesn't mean that. And so the justices took the discretion that was given to them, and that's where they ran with it. So, a lot of these problems that I've laid out, a lot of the problems I could talk about from a historic perspective, come from the fact that our law tends to be very malleable. It's not always written, whether it's an ordinary statute or the Constitution itself, with a great deal of precision. And in those cases, it operates to delegate to these 9 unelected officials, the power to interpret it, not necessarily however they want, but, they have a great deal of discretion to choose how they want to read it.
Clarification?
Well, I'm just going to say, I think we're probably right at the end of our time limit here. A lot of folks may need to go, but Ian will be here for a while. We've got to take him to a flight at the airport at 3:30, but he's got a little more time. So, and do follow him at thinkprogress.org. That's the place to go. Thinkprogress.org is the website where this newsroom is producing all kinds of amazing stuff, covering what's going on in the federal government. They have a specific section devoted to justice issues where Ian pulls forth and reports the news, and it's a very illuminating place. Do check it out. Come up and talk to him afterwards, and look for an announcement of our next luncheon. Thanks very much for coming.